Why are you trying to hide your name and badge number?
I am not.
You answer to me.
I do not.
I would like if we could uphold the Constitution and allow freedom of press in our courtrooms.
Watch out, that's a lawbreaker right here. You like to break the law, be careful. No, I don't answer to you.
Okay,
I'm free. You're dismissed.
I am not dismissed.
Yes, you are.
Who the fuck is at my window?
Do we enforce law around here or do we enforce will?
Who the fuck are you? Shining your lights in my window!
Hey, you need to leave.
I don't have
You're
to.
dismissed.
I'm not dismissed.
You are.
Actually, I think I'll do a foot patrol in this area.
Go ahead. Don't step on my property. You will be trespassing. It's here.
Lower your voice.
You need to leave my property. You are trespassing. You are trespassing. You're going to be going to jail. Follow the law. And what's your name and badge number? Why are you harassing me? Oh, you did? Were you fucking blind the 5 times you drove by? Which one of you honked at me?
Don't bring your hands on me. We won't be needing your gloves, sir. You can take the gloves off. We don't need the gloves. Nobody needs to put their hands on me. And I do not need escorted.
Leave my property now. This is private property. You are trespassing. Leave now.
Do not walk on this fucking
What
property.
is your name?
Howdy everybody, I'm Mr. Abbott and you are watching The Defenders of Rights. This is a follow-up video to my first one. I'm going to explain to you what's been going on, how everything's been going, and I'm going to show you the amounts of paperwork, as you can see, that is involved with exercising our First Amendment right to petition the government for redress of our grievances because I have been injured. I have been denied due process of law, which is my 14th Amendment right. I have the right to receive due process of law whenever my life, liberty, or property is in jeopardy. My children have been injured, Jessica has been injured, our neighbors have been injured, immediate family members have been injured. None of us have committed a crime. We are completely innocent, so therefore we're going to stand and fight as we have been. So as you already know, I was denied due process of law in the courtroom of Bartholomew County by Magistrate Joseph Meek. I brought 5 witnesses with me to testify on a penalty of perjury that this did occur. As you already know, ladies and gentlemen, I am taking this to the Supreme Court. Why? Because the Bartholomew County Superior Court 2 has lost jurisdiction. I'm going to go ahead and put up on the screen a Supreme Court case here in the Indiana Republic declaring what I have just said. Now before I read the court case I just spoke of, which is State Ex Rel Rose versus Hoffman from the Supreme Court of the Indiana Republic, I'm going to read to you another court case. This is also from the Supreme Court of the Indiana Republic back in 1943. It is Wilson versus State. This court case puts it into perspective of how judges and magistrates shall conduct their courts accordingly. Listen to this, end quote. It was held in Powell versus Alabama that the specific provision of Article 6 did not exclude that right from the protection of the Due Process Clause of the 14th Amendment. If the accused, however, is not represented by counsel and has not competently and intelligently waived his constitutional right, the 6th Amendment stands as a jurisdictional bar to a valid conviction and sentence depriving him of his life or his liberty. As pointed out in the beginning, the United States Supreme Court has held that, under the federal Constitution, there could be no valid trial of a criminal case unless the defendant is adequately defended by counsel, and that a judgment rendered under such circumstances is void. This court has consistently held that, under the Constitution of Indiana, there could be no valid judgment against a defendant in a criminal case unless he has been offered and, if so desired, provided with adequate counsel. It will be noted that by the use of the word adequate, this statement goes somewhat farther than the express provision of either constitution. In a recent opinion, we said, it is the duty of the trial court to appoint competent counsel to advise the defendant in the first instance. So this court case is already setting the tone for every single defendant. If you are not represented by competent and adequate counsel, then you have already had your constitutional rights violated. Most importantly, if you do not ask or receive counsel, and you are defending yourself, not representing, defending yourself, you most definitely deserve more respect and to be able to go through the court process with respect and with dignity and without being intruded by any government interference. And by that I mean clerks not taking your court papers, judges being biased and prejudiced, so on and so forth. Let's continue on. The spirit of these constitutional provisions requires that an accused must have something more than a perfunctory representation. This is true whether the attorney is appointed by the court or engaged by the accused. The constitutional provisions above mentioned also guarantee the accused a public trial by an impartial jury. It is equally important that the judge be impartial. This is a concept of ancient origin inherent in the common law. Our much abused statutes permitting change of venue from a judge on account of bias and prejudice recognize this basic right. The federal practice permitting the judge to comment on the evidence does not prevail in our state courts. A fair-minded judge observing the incompetency of an attorney for the defense would be expected to take more than ordinary care to protect the rights of the accused. It was not so in this case. He not only examined and cross-examined witnesses beyond reasonable bounds, but on the several mentioned occasions must have improperly influenced the jury by indicating the appellant's defense was without merit and his testimony false. His conduct of the trial was quite unfair. We would not leave the impression that the trial judge was motivated by ill will or malice. But none of this excuses or alleviates the prejudice engendered against the appellant by the unjudicial innuendo and argument to the jury. A competent lawyer for the defense very early in the trial would by objection have reminded the judge of his judicial duty. When it is made to appear by a record before us that a so-called trial did not meet the requirements of due process of law, it is within the power of this court to take cognizance of the errors that resulted in depriving the appellant of his constitutional rights. When, as here, there has been such a lack of representation as to be equivalent to, or worse than no representation whatsoever, and as a result thereof the judge misused the opportunity thus given to impress upon the jury his view that the defendant was guilty and ought to be convicted, we are left with, as will not deny but will afford to the accused, the protection guaranteed by our Bill of Rights and the Constitution of the United States." End quote. So this court made it clear that judges and magistrates are bound by oath to support and defend the Constitution and the Bill of Rights. And they are meant to afford the accused, any party, defendant, aggrieved defendant, plaintiff, they are guaranteed to protect their constitutional rights. And when a judge or magistrate during a court proceeding knowingly and intentionally and openly violates constitutional rights of a party, that is called an excess of jurisdiction. They no longer have jurisdiction, they lose it automatically. And that's what I'm about to get to. First, I want to go over the court case People ex rel. Sammons versus Snow. This is the Supreme Court of the Illinois Republic in 1930, and this case declares, end quote, "The constitutional right to be admitted to a reasonable bail cannot be disregarded. The judge has no more right to disregard and violate the Constitution than the criminal has to violate the law. It is the duty of the courts to support and maintain the Constitution, and if the judges, who have taken an oath to support the Constitution, openly violate it, how can they expect the courts to retain the confidence and respect of the people? A criminal may have forfeited his right to liberty, but neither courts nor any other power have the right to deprive him of it, except in accordance with the law of the land." Let me sum it up for you. If judges and magistrates, if any judicial officer happens to start violating the law, openly violating people's constitutional rights, denying them due process of law, anarchy will come after. Nobody's there to uphold the law. Therefore, there won't be no law. It's a crime for judges and magistrates to do so. That's going against what country has been... That's going against what this country has been established from the very beginning. Okay, and according to Black's Law Dictionary, 6th edition, published year 1990, page 562, excess of jurisdiction is defined as a case in which court has initially proceeded properly within its jurisdiction, but steps out of jurisdiction in making of some order or in the doing of some judicial act. Acts which exceed defined power of court in any instance. A departure by a court from those recognized and established requirements of law, however close apparent adherence to mere form and method of procedure, which has the effect of depriving one of a constitutional right, is an excess of jurisdiction. So when any public official steps outside his delegated authority, he's no longer acting within his office. He is outside of his jurisdiction. He has no power. An excellent court case that explains what an excess of jurisdiction means is Auto Equity Sales Incorporation versus Superior Court. This was the Supreme Court of the California Republic in 1962. End quote. Speaking generally, any acts which exceed the defined power of a court in any instance, whether that power be defined by constitutional provision, express statutory declaration, or rules developed by the courts and followed under the doctrine of stare decisis, are in the excess of jurisdiction, insofar as that term is used to indicate that those acts may be restrained by prohibition or annulled on certiorari. So they're saying right here that the court can exceed its jurisdiction in a constitutional sense, in a statutory sense, or in a court rules sense. And this court goes further on to say, end quote, under the doctrine of stare decisis, all tribunals exercising inferior jurisdiction are required to follow decisions of courts exercising superior jurisdiction. Otherwise, the doctrine of stare decisis makes no sense. The decisions of this court are binding upon and must be followed by all the state courts of California. Decisions of every division of the District Courts of Appeals are binding upon all the justice and municipal courts and upon all the superior courts of this state. And this is so whether or not the superior court is acting as a trial or appellate court. Courts exercising inferior jurisdiction must accept the law declared by courts of superior jurisdiction. It is not their function to attempt to overrule decisions of a higher court. So clearly they are talking about stare decisis, which is another way of saying precedents. The higher courts, the Supreme Courts, are what set precedents for the lower courts. And precedents is the established rule of law, defined and promulgated by the higher courts, in which the inferior courts are bound to follow. And of course, there's a lot of precedents set on constitutional violations and the process how to go about it and due process of law. And these inferior courts must follow the set precedents, the stare decisis. And so speaking of due process of law, everybody is guaranteed when they go to court to receive due process of law. And what is due process of law? Well, it is defined very well in Frank versus Magnum. This was the United States Supreme Court in 1915. End quote. As to the due process of law that is required by the 14th Amendment, it is perfectly well settled that a criminal prosecution in the courts of a state, based upon a law not in itself repugnant to the federal constitution, and conducted according to the settled course of judicial proceedings as established by the law of the state, so long as it includes notice and a hearing or an opportunity to be heard before a court of competent jurisdiction according to established modes of procedure, is due process in the constitutional sense. So, clearly saying that due process of law requires that the parties be notified and there be a hearing, and also have an opportunity to be heard. These are the requirements of due process of law. Violate those and your constitutional rights have been violated. So the message I'm trying to say here is when seeking a remedy, whenever an inferior court or trial court proceeds to act in excess of its jurisdiction, such as violating constitutionally protected and secured rights of one constitutional private citizen of the Indiana Republic, American citizen, or state national, or more, the inferior court loses all jurisdiction, and any judgment sustained from a denial of constitutional rights is automatically void. Jurisdiction immediately goes to the Supreme Court, who has original jurisdiction and must provide the remedy. Acts committed such as a denial, infringement, or violation of a constitutional right are malum in se. And according to Black's Law Dictionary, 6th edition, published year 1990, page 959, malum in se is defined as a wrong in itself, an act or case involving illegality from the very nature of the transaction, upon principles of natural, moral, and public law. An act is said to be malum in se when it is inherently and essentially evil, that is, immoral in its nature and injurious in its consequences, without any regard to the fact of it being noticed or punished by the law of the state. Such are most or all of the offense cognizable at common law. So any acts committed, such as the denial, infringement, or violation of a constitutional right, are malum in se. So when a judge violates your constitutional rights, when he denies you due process of law, he is acting in malum in se. And so again, what happens when your constitutional rights have been violated or you've been denied due process of law? Well, let's go to Graham versus State. This was the Supreme Court of the Indiana Republic in 1969. And let's see what they have to say on the subject. End quote. Where an accused has been deprived of his constitutional rights, negligence of counsel cannot be permitted to prejudice such rights of an accused where his life or liberty are involved. This court has the power, and it should be its duty to waive any given rule where 1. An accused has been deprived of his constitutional rights either under our Bill of Rights or under the 14th Amendment, or 2. Where upon an examination of the entire record it appears that substantial justice has not been administered. So any given rule that the court may have, it can toss it out the window when it comes to somebody having their constitutional rights violated. So any judge or magistrate that's giving you excuses on anything when it comes to a rule, or even stare decisis, for that matter, even set precedent. When it comes to your rights trump all of that. The Constitution trumps all of that. Now let's get to the juicy stuff. Case law stating a deprivation of constitutional rights by a trial court is automatically void and they lose jurisdiction. First court case is City of New Albany versus Binya. This was the Supreme Court of the Mississippi Republic in 1956. In quote, whenever an inferior court proceeds to act in excess of its jurisdiction, and whenever, as incidental to its action, it involves an infringement of property rights, of a submission to multitudinous and persecuting prosecutions in such a way as to make its acts oppressive, there is no adequate remedy by appeal, and it is proper to issue the writ of prohibition. And this is true, whether the court in which the proceeding is instituted has acted or not, if the effect of the void authority under which it is assuming to act stands as a vexatious menace to personal liberty or the destruction of property rights. Well said. Next we have Hammer versus State. This was the Supreme Judicial Court of the Maine Republic in 1966. In quote, we recognize that on the deprivation of constitutional rights, the court thereby loses jurisdiction of the cause. It is true that upon deprivation of the constitutional right to counsel representation, the court loses jurisdiction to proceed further with the case, that the judgment of conviction pronounced under such circumstances is void, and one imprisoned thereunder may obtain release through habeas corpus. Next court case we have Ostwald versus State. This was the Supreme Court of the Wyoming Republic in 1975. In quote, a number of cases supporting the view that unconstitutional action is void are cited and quoted from, and in my opinion, our court clearly accepts the principle that proceedings in violation of one's constitutional rights are considered not erroneous, but void. The refusal of the court to grant each of the rights above enumerated, or all of them, goes to the jurisdiction, and if the court has jurisdiction to try the action, it seems to lose jurisdiction once acquired, by a disobedience of the mandates of the Constitution, or rather, the trial ceases to be a legal trial by a deviation from this course. Therefore, when any constitutional right or immunity of a person is violated, the judgment of the court is void. Next court case is Ritchie, etc. versus Sheiks. This was the Court of Appeals of the Indiana Republic in 1967. In quote, it is a universal principle as old as the law that the proceedings of a court without jurisdiction are a nullity and its judgment void. Now, not all court cases where constitutional rights are violated or due process of law is violated is it an automatic void judgment. There are some that are voidable and there's some that are void. It depends on what constitutional right or due process violation has occurred. This next court case kind of goes into detail about that. We have Kuntz versus Finney. This was the Court of Appeals of the Indiana Republic in 2017. In quote, the distinction between the terms void and voidable is critical in this context. A decision that is void has no legal effect at any time and cannot be confirmed or ratified by subsequent action or inaction, and is subject to a collateral attack. A decision which is voidable has legal effect until such time as challenged in the appropriate manner and can be ratified or confirmed by subsequent action or inaction, and may only be attacked through a direct appeal. To act in a given case, a trial court must possess both subject matter jurisdiction and personal jurisdiction. Subject matter jurisdiction exists when the Indiana Constitution or a statute grants the court the power to hear and decide cases of general class to which any particular proceeding belongs. Personal jurisdiction exists when a defendant both has sufficient minimum contacts within the state to justify a court subjecting the defendant to its control and has received proper notice of a suit against him in that court. A judgment may be void for want of authority in a court to render the particular judgment, though the court may have jurisdiction over the subject matter and the parties. An abuse of discretion occurs if the decision was against the logic and effect of the facts and circumstances before the court, or if the court misapplied the law. So there's a couple of set precedents that this court is applying.
Definitely want to jot them down and know those. Next is the court case that I was primarily speaking of. This is State ex rel Rose versus Hoffman, the judge, the Supreme Court of the Indiana Republic in 1949. End quote. Any rule which assumes to take away the right of the defendant in a criminal case to a jury trial is repugnant to the laws of the state. It seems to be accepted law that where a defendant in a criminal case is denied his constitutional rights by a trial court, that court has no jurisdiction to proceed further with the prosecution. Under this state of facts, Realtor was not required to wait until a trial was completed by a court that had lost jurisdiction of the case, and then appeal for the void decision. Since the right to a jury trial is a fundamental right of every defendant in a criminal action, it is not waived by a defendant unless such waiver is made agreeable with the statute providing therefor. The prompt disposal of a criminal case may not be accomplished by taking fundamental rights from a defendant. When a defendant in a criminal case, before the beginning of his trial, asks for a jury, the trial judge is not called upon to exercise the discretion in the matter. He has an imperative duty to grant the request. Under our Constitution, Article 1, Section 13, it is the duty of a judge in a criminal case to assume that a defendant will want a jury trial and to arrange the affairs of this court accordingly, unless and until the defendant and the prosecuting attorney, with the assent of the court, shall have waived that right agreeable with the statute. Conflicts with the Constitution. No rule, no matter how completely prepared and promulgated, can empower a court to take action that conflicts with the Constitution of the state, with the general principle of law, or the provisions of a constitutional statute. End quote. So as you can see, that court case right there is still set as precedent. It has not been overruled or overturned still to this day. This is binding upon all inferior courts as well as the Supreme Court. And for all you Americans out there who are domiciled in another state of the Union, you definitely use this case too. Why? Because this case has full faith and credit. And the full faith and credit clause allows you to use this. Like I said, it's set precedents. It's an accepted law that when a defendant in a criminal case is denied his constitutional rights by a trial court, that court has no jurisdiction to proceed further with the prosecution. And under that state of facts, the realtor, who is the one bringing the petition to the Supreme Court against the trial court, was not required to wait until the trial was completed by the court that had lost jurisdiction of the case, and then appeal for the void decision. You don't have to wait. You automatically, as soon as they violate your constitutional rights or due process of law rights, they're done. They lose jurisdiction. Whatever they have, whatever they say, whatever they do from there on out is void. Okay? You send your butts right on to the Supreme Court so they can overrule that and get you a fair trial. And of course, if you're summoned into court, obviously you violated a statute. Here in the Indiana Republic, all crimes are defined by statute. Okay? And those statutes that deal with crimes are construed in a strict sense. And by that, I'll let the Supreme Court of the Indiana Republic explain that. In White versus Dowd and Warden, the Supreme Court of the Indiana Republic in 1951 said this, end quote, "Since the protection and security of the natural rights of all persons, particularly to life, liberty, and the pursuit of happiness, are the principal elements upon which the entire Bill of Rights of our state constitution is based, I do not believe that appellants or any other person's right to liberty can be taken away and he or they be placed in involuntary servitude for life because of a status. If we heed the Constitution of the state, this could be done only for the commission of a heinous crime." Of course, in Indiana, all crimes are defined by statute. Where there is no statute defining the crime, there is no crime. The language of a criminal statute cannot be extended beyond its reasonable meaning. And wherever the court entertains a reasonable doubt as to the meaning, the doubt must be resolved in favor of the accused. The court must expound what it finds written, and it cannot import additional meaning without sufficient indication thereof in the words of the statute, which such aids thereto as to established rules of law authorize. In the absence of any other apparent purpose of the legislature, the statute should be read as written, and all parts and terms therein should be considered together, with reference to their connections and to the subject to which the statute relates. It is a fundamental rule in the construction of statutes that penal statutes must be construed strictly. Under the rule of strict construction, such statutes will not be enlarged by implication or intendment beyond the fair meaning of the language used. Let me stop right there for a second. So statutes are meant to be read as they are written. And each statute pertains to a subject matter, one subject matter. And it has to stick with that. The courts cannot interpret it this way and then interpret it that way. The courts are bound to follow precedents. Whatever the higher courts determine is the law and how it's meant to be interpreted, that is how it's meant to be interpreted. The statutes are not meant to be enlarged. They're meant to be interpreted in a strict sense, in favor of the accused. Let's continue on. But statutes which take away, change, or diminish fundamental rights, statutory remedies for rights unknown to the common law, and statutes which provide new and extraordinary remedies must be construed strictly, both as to the cases embraced within their terms and as to the methods to be pursued. It has been held by this court frequently that all statutes relating to criminal proceedings must be strictly construed in favor of a defendant and against the state. The right of every person to liberty in this state and nation cannot be taken away permanently or even temporarily except in the specific manner provided by the law authorizing it. On the contrary, it makes a vast difference to the defendant and an even greater difference to the majesty of the law, for it takes away defendant's liberty for life without giving him due process of law as provided by our constitutions and by the statute under authority of which the trial court and this court must act in this matter. Statutes facilitating the enforcement of such rights would be proper, but those limiting such rights as to the time of asserting them or otherwise are void. What we do to this defendant in this matter is a precedent for action against any or all of the citizens of the state when and if government may desire absolute control. If we may ignore or bypass one constitutional protection to personal liberty, we may with equal ease and abandon ignore them all. That court case also is set precedence. That has not been overturned or overruled. That is binding upon all courts, superior and inferior. So any of you who have allegedly violated the statute or committed a crime, you need to apply this court case. Because I'm sure the trial court isn't enlarging its meaning, its intent of the legislature. Criminal statutes are meant to be strictly construed and in favor of you and against the state. And no constitutional rights or due process of law shall be violated whatsoever.
Okay, now that I've provided you some clarity on the matter, it doesn't stop there. Now when you go to the Supreme Court, there's a lot of procedure in place. There's a lot of rules and regulations that you must follow. There's a lot of requirements you must meet before the Supreme Court could even accept you. But first things first, you must do what I did. You must learn the law. You must learn every facet of the law. And trust me, the law is in everything, and everything in a part of your everyday life. There's a reason why they didn't teach us the law in school. Because it is so powerful. When you're on the side of the law, it's like a blanket and it protects you and it saturates you with knowledge and power. Because with the law comes power. It's like being a superhero. It really is. Learning the law for me, it was just natural. Okay, naturally, I was born to help people. I'm a people person. I love helping. I love my neighbors. And by neighbors, I mean every single individual here on earth. And with learning the law, it gives me purpose. It gives me meaning. It fulfills my destiny when it comes to helping others. So this is why I'm fighting these tyrants. It's for you. It's for me. It's for my family. So to sum it all up, learning the law is detrimental to our survival. Especially nowadays. So that's the first facet of the law that you must learn. Second is how to apply it. Okay, this is where procedure comes in. And since we're specifically dealing with the Supreme Court, there's a couple things that you must do. All the higher courts go off what's on record for the trial court. So, half the battle is on record. You must file all that you can to get your story out, to get your side out, to get the law on your side. And if you haven't committed a crime, if you haven't violated the law is always going to be on your side. So this is where you need to learn how to draw up affidavits, motions, petitions, averments, anything and everything. Those come in handy. Those are key when it comes to dealing with the superior courts, the higher courts, because they specifically go off what's on record. So, since my domicile is here in the Indiana Republic, we're going to specifically deal with the Supreme Court rules here. Of course, it is very similar in every state of the Union. Let's take a look, shall we?
Okay, so the procedure to follow when filing to the Supreme Court here in the Indiana Republic is dictated by the Indiana Rules of Court. This is the Rules of Procedure for Original Action Writs of Mandate and Prohibition. And that Rule 1 is the scope of rules, and it explains how the Supreme Court has exclusive original jurisdiction over certain things, and where it derives its rules from, such as the Indiana Appellate Rule 22B for original actions. Now, Rule 2 goes over the applications for writs, and the conditions precedent to making applications for writs. No writ of mandamus or prohibition will be entertained unless the realtor, who is the individual bringing the petition to the Supreme Court, has raised the jurisdictional question by written motion with the trial court. So, like I said before, it is so important and imperative that you make sure you get your side and your story and the truth on record. That's 50% of the battle, is putting everything on record. And so to be successful going to the Supreme Court, you must have filed a motion to dismiss with the trial court. You must have raised the jurisdictional question. You must have challenged the jurisdiction of the trial court. And this also explains if the application is incomplete or in improper form, and you failed to meet its requirements, then the Chief Justice can deny the application. He can dismiss it. The most important rule, and this is Rule 3. This is the application papers. Now, I'm going to go ahead and read this to you. A. Petition. All applications for writs of mandamus or prohibition shall be made by petition. The petition shall be verified and affirmed, and shall state facts showing clearly that 1. The Supreme Court has jurisdiction over the application as an original action. Now, 1 is very imperative. The Supreme Court here in the Indiana Republic has original jurisdiction with certain things. And you can go ahead and relate back to the Indiana Republic Constitution of 1851. It'll set the standards in Article 7 for the judicial branch. 2. The application is made expeditiously after the jurisdiction of the respondent court became an issue. Okay, what this saying here is the application is made quickly after the jurisdiction of the respondent court became an issue. Either they lost jurisdiction, or there's a jurisdictional question that needs to be answered that the trial court can't address. The Supreme Court must determine if there is, in fact, a jurisdictional question or not. If there's a jurisdictional issue, such as subject matter jurisdiction or persona jurisdiction. 3. The respondent court has exceeded its jurisdiction, or the respondent court has failed to act when it was under a duty to act. Now, when a court exceeds its jurisdiction, as I just so eloquently put it beforehand, when constitutional rights are violated, when due process is denied, these things automatically the trial court loses jurisdiction. Okay, and when the judge fails to act on his constitutional mandates or statutory mandates, then the court loses jurisdiction. If he or she violates the Indiana Code of Judicial Conduct, then he fails to act, or she fails to act when they have a duty to act, and loses jurisdiction. 4. The absence of jurisdiction of the respondent court, or the failure of the respondent court to act when it was under a duty to act, has been raised in the respondent court by a written motion filed therein, and brought to the attention of the respondent judge, and the written motion has been denied or not ruled on timely, provided, however, that the petition need not show this in applications involving a change of venue from the judge or county. And again, the Supreme Court is strictly going off what's on record in the trial courts. Therefore, it is so imperative you put everything on record. Number 5. The denial of the application will result in an extreme hardship. So you must show to the Supreme Court that if they deny this application, you and your family will suffer dramatically. Physically, mentally, emotionally, spiritually. Such as in my case, there is extreme hardship if they so happen to deny my permanent writ of mandamus and prohibition, as well as the emergency writ. And then number 6, the remedy available by appeal will be wholly inadequate. See form number 1. Okay, when constitutional rights or due process is violated or denied, you can't go to appeal and get it taken care of. The court automatically loses jurisdiction, so whatever judgment they have is void. Okay, this needs to go to the Supreme Court because the Supreme Court is in charge of all the judges and magistrates across the Indiana Republic. It is their duty to take care of the issue, not the Court of Appeals. Original action applications which do not include all of the applicable allegations listed above shall be rejected by the Chief Justice or Acting Chief Justice. And the Chief Justice here, currently in the Indiana Republic, is Chief Justice Loretta Rush. She is the first female to be in the Supreme Court here in the Indiana Republic. Go her. That's awesome. We'll be seeing her soon. I hope she is a good woman, has a good heart, and takes her oath of office seriously, and takes her occupation seriously, and takes the constitutional mandates seriously. I can only hope and pray. And when you go to B, it describes the brief, and how you can submit with the petition a supporting brief. And that's where you can list all the cases, statutes, and other authorities relied upon in your defense. Now, number C is an important one, record of proceedings. This is the certification. At the time the realtor submits the original action petition, the realtor shall submit a certified record of the proceedings from the respondent court. The record shall contain copies of all relevant pleadings, motions, orders, entries, and other papers filed, tendered for filing, or entered into the respondent court. So when you file this petition to the Supreme Court, you need to include all relevant pleadings or motions, affidavits, entries, orders, or other papers into the record with the petition. Because remind you, the Supreme Court goes off of what's on record. So it's imperative you send what's best for your defense, what they need to know, and need to hear, and need to determine. The record also shall include a current copy of the chronological case summary. In this instance, here in the Indiana Republic, you can go ahead and get that off of indiana.gov. When you go to mycase.indiana.gov, you can get the chronological case summary there. In the event a relevant transcript of any evidence in the record exists, it shall be submitted and shall be certified by the appropriate court reporter and the respondent judge. The last page of the original action record shall be a certificate of the clerk of the respondent court, which clearly demonstrates that all the papers contained in the record have been filed, tendered for filing, or entered into the respondent court. And of course, D covers the filing fee. The realtor shall tender the filing fee of $250 when the realtor submits the original action application to the Supreme Court administrator. The fee is not applicable in a case prosecuted as a pauper cause or on behalf of a governmental unit. If the realtor seeks pauper status, realtor shall submit with the original action papers an affidavit of indigency detailing realtor's assets and financial condition and seeking waiver of the filing fee. So if you don't have the money to cover this, obviously you can file a verified affidavit of indigency. And this will obviously show the Supreme Court that you aren't financially capable of supplying them with the sufficient amount of money for them to have to view this application. And E goes over the writs. A permanent writ form shall be submitted, and an alternative writ form may also be submitted by the realtor. If emergency relief is sought, an emergency writ form also shall be submitted. Now let's go over one, and it's the emergency writ. An emergency writ is an order that may be granted prior to a hearing. It must be accompanied by a petition for emergency writ demonstrating that a writ must be issued to maintain the status quo and prevent irreparable injury until the application can be heard. The emergency writ operates as a temporary stay of the trial court proceedings until the Supreme Court hears and rules upon the original action application. All original action applications, which include a request for emergency writ, shall be presented in person to the Supreme Court Administrator after personal service on the respondents and all other interested parties. The Administrator shall submit all applications for emergency writ to the Chief Justice, if available, or to the Acting Chief Justice for determination as to whether or not a sufficient emergency exists to require a stay. Number 2 covers the alternative writ. And in this, it explains a petition of mandamus and a petition for prohibition. An alternative writ is an order that requires respondents to take action, mandamus, to cease action, prohibition, or both. If an alternative writ is issued, the respondents shall file a return with the court no later than 20 days after the filing of the writ. A return is a pleading submitted by the respondent court showing compliance with the writ or stating reasons why the writ should not be made permanent. The return shall be submitted in person or by mail to the Supreme Court clerk for filing. And then number 3 covers the permanent writ. And a permanent writ is an order issued after the application is made, which is immediately permanent. It dispenses with the general practice of allowing the respondents to file a return. F is notice of hearing, and the realtor shall submit a notice of hearing with the realtor's original action petition, leaving the date and time of the hearing blank. See form number 4. And at the bottom of this, there's 5 forms that they issue you, and one of those is a notice of hearing. Now H is numbers of copies, and each party shall submit to the administrator the original and 5 copies of each application paper, including the record. So everything that you're going to include into this petition, there needs to be a total of 7 or 8. And the determination on that is whether it's a civil case or a criminal case. In a criminal case, one must address the Attorney General of the State of the Union. If it's a civil case, then all you need is the original copy for the administrator and then 5 copies. And why 5 copies? Because there are 5 justices here in the Indiana Republic. So you need to give them a total of 6 over there when you either mail it or deliver it in person. And of course, if you're doing an emergency writ, you need to do it in person. It's better just to serve the opposing party and whoever else is involved by person. And you also must include the record. That's the chronological case summary and all the other relevant pleadings or motions, orders, entries, affidavits, or other papers filed to the trial court. And I is production. All application papers shall be typewritten or printed on 8.5 by 11 inch white, opaque, unglazed paper of a weight normally used in legal typing and printing, and shall be reproduced by a copying or duplicating process that produces a clear black image. Rule 4 is hearing on applications. A covers the scheduling of hearing. The Supreme Court may set the hearing on the application for a date usually not less than 1 week from the date of submission of the application to the administrator. An earlier hearing date may be authorized if Realtor establishes in Realtor's original action petition or emergency writ petition that an extreme emergency exists which necessitates an earlier hearing. Now with an emergency writ, the Supreme Court has 3 to 5 days to respond and to stay the proceedings of the trial court, whereas the rest of them, the Supreme Court may set the hearing on the application for a date usually not less than 1 week from the date of submission of the application to the administrator. So it usually takes them over a week to determine if there will be a hearing or not. And so that's why if the court loses jurisdiction and are issuing body attachments or criminal warrants, you're being hunted down, violated by not just the judges or magistrates, also the law enforcement in your community, and that's where an emergency writ takes place. That is where you need to file an emergency writ. It's there for that purpose. And it'll stay all the proceedings. It'll take away all those void judgments, and all those void warrants, everything. Rule 5. Disposition of applications. A. Application granted. Issuance of writ. Filing with clerk. Disposition. If the application for writ of mandamus or prohibition is granted, either an alternative or permanent writ will be issued. If the alternative writ is issued, the respondent court shall be given 20 days to file a return. See Original Action Rule 3E2. The return shall show compliance with the writ or state reasons why the writ should not be made permanent. If the return shows compliance with the alternative writ, the Supreme Court will enter an order dismissing the original action as moot. If the return contests the alternative writ, the realtor shall have 5 days after service of the return to file a brief in opposition to the return. Any parties opposing the alternative writ other than the respondents also may file a further brief no later than 5 days after service of the return. Let's go to Rule 6, Submission, Filing, and Service of Application Papers. Let's go down to E, Service on Attorney General when required. In all original actions arising out of criminal cases and in all other original actions in which the state of Indiana has or may have an interest, each party shall serve the Attorney General with a copy of each paper submitted to the administrator or filed with the clerk. And as I said before, any criminal case, you need to address the Attorney General as well. You need to have all of the foregoing paperwork that you send to the administrator. And F, proof of service of all application papers submitted to the administrator or filed with the clerk required. When personal service is required of realtor, or where personal service is made but not required, 2 copies of the acknowledgement of service or certificate of service shall be submitted as soon as service is accomplished. The certificate of service shall be signed by the person making service. The acknowledgement of service shall be signed by the person served. The acknowledgement or certificate of service shall state the date of service and the address of each person served. Now, in the certificate of service, you'll see down here it's Form 6, Certificate of Service Form. Before you print that off, you need to make sure that you mention all the copies of the paperwork that you have and that's going to be submitted to the administrator, such as the certificate of service, the notice of hearing, the emergency writ, either an alternative or permanent writ, and any other relevant paperwork that you file with the trial court that you're going to turn in with this petition. You need to have that all into the certificate of service. And you need to mention if you're going to mail it or if you're going to deliver it in person. Don't do both. You have to put either one. This will prevent any confusion or prevent you from having your petition denied for reason of improper form. Now remember, it's either the permanent writ or the alternative writ where you add on and tell your story and why you are addressing the Supreme Court, and obviously include those 6 requirements that you must meet and explain for the Supreme Court to hear your case. You got to put that in the alternative writ or the permanent writ. And most likely it's going to be the permanent writ that you'll be using.
Just remember, when you are filing anything with the courts, especially the Supreme Court, you want to make sure everything is in order. Make sure all the pages are numbered down at the bottom. Make sure all the captions are there. Make sure everything is set and prepared, because you don't want to get all the paperwork sent back because of improper form. There's procedures to follow. There's rules to follow. We got to start holding these public officials accountable to the law. We got to start filling out these complaint forms, these criminal complaint forms. And instead of going to the prosecutor to try to seek a remedy, we need to start going to the grand jury. They can do their own investigations. They can subpoena anybody to them. Investigate every single crime that has been committed, especially crimes that have been committed by public officials, because they are bound by oath to uphold, defend, and protect the law. And that means to uphold, protect, and defend our constitutionally protected and secured rights. And of course right now they're not doing that, so that's why you get us, the defenders of rights. I hope this video was educational. We just wanted to inform the audience on the initiatives and the objectives that we have next to fight this corrupt system. There are steps to take, and we must take those. And time is of the essence, as always. But soon I'm going to be a free man. I'm going to be able to be out there with Jessica and Josh, with Suspicious Activity 81, and whoever else might be willing to assist us in this war. And of course, when we go to the Supreme Court, you know we're going to be recording, exercising our First Amendment right. We're going to bring it all to you guys. So sit back, relax, grab some popcorn, and be prepared. Because we are going to continue to show you how to defend your rights.